this particular case. That is the case of Van Rooyen. I gave full citation at paragraph 13 of the head. But the caveat is that this case is written in Afrikaans, so this is the translated version, but it does still contain the gist of what was said. So it reads as follows, open quote. Should every defendant who, during the course of a criminal case, believes that his or her fundamental rights are being violated, or that there is an imminent violation of such a fundamental right, ask the trial court to be suspended first in order to approach the motion court. It says, in my opinion, none of the rights enshrined in terms of section 35(3) of the Constitution necessarily lend themselves to that introduction of motion court procedure. If an accused's rights are violated during his trial, and that violation directly impacts on the question of whether his trial is fair or not, the designated forum is the trial court. Close quote. So it sets the tone, it answers everything that needs to be answered. It starts this case and it ends this case. And that is exactly the applicant's complaint, who is also accused number 7 in terms of the criminal proceeding citation.
Mr. Moela, I think before we even go further, while we are still dealing with that issue, just on that quotation on its own, when you say should it become apparent during the process in a criminal trial that an accused's rights are threatened, that the process of determining whether the accused's rights are threatened or not, there should be certain role players in that process. I think we should start with fundamentals here. In a criminal trial, who are the role players?
The accused and the state.
Who is the state? Who is the state?
The state is represented by the National Prosecuting Authority. It prosecutes on behalf of the state. That's why in a criminal citation, you find the state versus the accused. So it's not the NPA versus the accused. So the state in terms of the Constitution. And we outline that in the founding papers.
And where is the NPA in this matter?
The NPA in this matter, they participated in the criminal trial. And before I even get that, because I need to say this. So we need to know why we are here and why we got here. Because
no, before we get that, I'm asking you this simple question: where is the NPA?
The NPA is represented because it represents the state. So if you look at our citation,
did you cite the NPA in your papers?
No, the NPA is not cited. It's the state that is cited. So
who is the state, Mr. Moela?
My lady, I think that question itself, it's not even. Let me answer it in two ways. Firstly, it's not unusual, this type of proceeding, because this division itself, if you can go to the case of Mukesi. In the case of Mukesi, of which we have relied in our heads of argument, if your ladyship will go to Mukesi, in our heads of argument, and the citation in the real case itself, they are, I just want to open the case of Mukesi and take your ladyship to the citation thereof and the parties. The case of Mukesi has, in fact, that is the case that left the criminal court and came to a civil court. And it was dismissed because the complaint was about Section 35 rights violation. But they left the criminal proceedings and came to a civil court. And on that basis, they were dismissed.
No, Mr. Moela, the case of Mukesi centered around the let's go back. The main question about the case of Mukesi was about the state providing the accused with further particulars, which is catered for within the Criminal Procedure Act itself. That process is catered for within the Criminal Procedure Act. That was what the accused were challenging there.
My lady,
in this situation, you are not within force with what had to be determined in Mokgesi.
I will take your ladyship to the words of Mokgesi, to the extent that my words might be falling short of what Mokgesi said.
But firstly, you should know what you brought here.
Yes.
And understand what was before court in Mokgesi. In Mokgesi, there was a different, they brought a different challenge from what you are bringing here. What you come before court and ask the court to give you is that the accused says, firstly, the treatment that I'm getting at the correctional services borders itself around violation of my basic rights, or my rights in terms of Section 35 as the accused, to a fair trial. And in your application, you are the applicant is challenging the conduct of the correctional services. But before we even go further into the merits of your application, of the applicant's application, I asked you a question. Where is the state? They are not here because they were not served. Where is the National Director of Prosecution?
My lady,
they are not here because they were not served.
I was answering that question. So your ladyship needs to understand in terms of how I wanted to outline this case. This case needs to be dealt with in this particular fashion. Firstly, how we got here in this court before your leadership. It's very important. And then thereafter, it's going to be followed by why we are here. And this is the outline that I intended. And this outline itself, as a matter of amplification, it answers, your ladyship asks several questions. Because I was trying to answer the first question and amplify with Mokgesi. Your ladyship put
No.
questions.
I actually stopped you with Mokgesi because you were wrong about what Mokgesi was all
I've
about.
not addressed that. I cannot be wrong if I've not addressed that. I simply said to your ladyship, Mokgesi is in front of me to the extent that I've not said anything, because I've only spoken about the citation. Mokgesi itself will tell this court what was the issue before it. And Mokgesi even said that the fair trial rights, complain about the fair trial rights, should be determined in the criminal court. I'll take your ladyship to the paragraph so that I think it will simplify this engagement, even though it was going to be simplified by first dealing with how did you get here. Because we are not here at our own insistence, and it's very important. Because we cannot be brought to a court and then hurdles are then placed of which we did not invite. In that criminal court, such was not there. So the citation, I want to take your ladyship to 3 paragraphs in Mokgesi. Paragraph 1, paragraph 3, and paragraph 38. I'm going to try to read them verbatim, and I'm going to demonstrate that it says contrary or slightly contrary to the sentiments passed by this court, and it supports our case. Firstly, paragraph 1. These are civil proceedings arising from the criminal prosecution of 16 accused. Then we must start doing this comparison. This now, before this court, assuming that we came at our insistence, to be civil proceedings arising out of a criminal proceedings. Mr. Bester, as identified as accused number 7, is before a criminal court. He's complaining about his fair trial rights. Number 3 says the following. All the applications are premised on the allegation that the fair trial rights of the accused in terms of Section 35(3) of the Constitution have been infringed. What is Mr. Bester alleging? My fair trial rights have been infringed, and because of cumulative treatment as well, they're going to be infringed. Because you must understand our application in 2 ways. One, he has not been able to consult meaningfully, so that's an infringement. And then he further says that the condition upon which it's kept, it's going to affect his mental health. So that's an apprehension that he might not have a fair trial, in the sense that if he comes to this court mentally unfit, he can't run a trial. So it needs to be understood. So this case has literally answered what I said this is our case. So Mukesi itself, in its own terms, it says exactly what our application says. In fact, when I drafted the application, I was not looking at it, but it would appear as if like I'm the one who drafted that Mukesi judgment, because it says what I said in our papers. Then paragraph 38 says the following: the court tasked with adjudicating a criminal trial, and we know which court is tasked to adjudicate a criminal trial, not this one, is the forum which must be approached with regard to the challenges or objections relating to the criminal charges during the course of the criminal trial. This includes challenges to the charges. So what your ladyship says that this case was all about, the case itself says that it includes, so it's not all that it was about. It says that it includes the challenges to charges or allegations that an accused person's fair trial right guaranteed in Section 35 of the Constitution have been infringed. Mr. Bester can't say further than this, lest we want to treat him differently from any other accused person, that their interpretation of your Section 35 must differ from the division of this court. While in his application, and we must understand when we are dealing with jurisdiction, we are not concerned with the substantive merits. Even if the case is wrong, your ladyship can even assume that our case is good, and actually we are going to argue that it's good, but not today, when we deal with the merits. You assume, in terms of Chira, in terms of Kawa, don't concern yourself with the merit. So if the applicant says to your ladyship, when you are dealing with jurisdiction, you must look at my pleadings, you have to look at Mr. Bester's pleadings.
Mr. I understand. I can see that you are quite getting excited with what you are doing, but let's come back and deal with the substance of what Mukesi was all about. The issue of the challenge on whether the accused in State versus Mukesi's rights were infringed were centered around Mr. Mukesi's complaint. Firstly, was that the charge, he was complaining about the charge against him, that it was formulated or he was arrested as a result of the evidence that came out of the Commission on State Capture, that is Zondo Commission. He was challenging the charge itself, the content of what was in the charge sheet envisaged for his criminal trial. That's what the complaint was all about. What the complaint is before me, the complaint that is before me today about Mr. Bester, is that the ill-treatment, he alleges that he's being ill-treated at the prison. And that, firstly, he is asking the court to find that the conduct by correctional services must be found to be unlawful. And the only way that can happen is through, it can be determined through the application as envisaged in Rule 6, which is catered for within the civil process.
My lady, I think we're going to commit serious mistakes here. And I understand your ladyship when I'm trying to argue my point passionately.
It's because you are getting lost in the process, Mr. Muela.
Can I make this point, my lady? And I think that some of the comments are just, I think they are unfair on me, but I won't complain that much. But I just read Mr. Mukesi. I have not disputed that Mr. Mukesi, obviously.
He was challenging the charge that was brought against him. Firstly, Mr. Mukesi, that was the content of his complaint. Not that there has been an ill treatment against him by a third party. in this process, in the criminal, let's go to Criminal Procedure 101. That's why I asked who are the role players within the criminal proceedings. And I said in the criminal proceedings, the role players, we cannot be sitting here today and say we are litigating a criminal case without the prosecutor. Firstly, I wanted to bring you back to this point that you didn't even cite them in your proceedings. You didn't cite the Director of Public Prosecution. That aside, the second thing is they were not. I perused this record to try and find the return of service in these papers. I couldn't locate it, Mr. Muyela. And in the normal, in any application proceedings, when you have to commence the application proceedings, what is the first step that has to be done?
My lady, I think that we are deviating from what we came here for, but I will answer because...
But before you come to that, before you start dealing with the merits, we have to start with how this matter was brought before me.
That's exactly.
And that's the first step.
Yes.
The first step of starting any proceedings. What should happen? I think you should answer me on that one now.
Yes, and exactly before the interruption, I had said that I'm going to start this.
No. Start first. Answer me.
How this case got here? We have my lady. We came here at the insistence of the judge president from the criminal court. So this matter was before the criminal court. This complaint. I'm trying to answer the question how we got here, because we got here because of that chronology, and I think I must be allowed to make that sequence because that is factual. I have a chain of email I've shared with my colleague. I beg leave to hand them so that it tells your ladyship this.
No, tell me how you came here.
Firstly, we were in the criminal court on the 29th of July.
Yes.
And we raised this complaint before that criminal court. So these papers that is before your ladyship were before the criminal court, except the replying affidavit, obviously, and the heads. So.
And what did the court say?
The court says, in its view, and not a finding, in its view, this matter, because we have prosecuted it in terms of the notice of application, because of other ancillary complaints that we are making, the same ancillary complaint that your ladyship has highlighted, which is not even the main complaint, but it's ancillary. Because of that ancillary complaint, they say that we must go to a civil court, and we invited the court to make a finding, a jurisdictional finding, whether the criminal court does not have jurisdiction to determine our complaint and not the ancillary complaint, because literally the grand norm of our complaint here is centered around the right.
And then after the court directed you that you should bring this matter here.
I'm trying to explain, my lady, because if I'm not given a chance to present the case, then the purpose would not be served.
Okay, proceed, Mr.
Yes.
Mel.
So, on the day, the JP said, this matter may I proceed?
Proceed.
Thank you, my lady. This matter would have to, the pleadings must be closed in a sense that we must file our reply and then the JP will then decide. We filed the reply and asked for a date in the criminal court, and we have the letter of the 30th of September, and that's why I wanted to hand it to your ladyship. It explains. It says that it was addressed at the registrar after the back and forth of the engagement, which forum will hear this. And it says that request for the date in the criminal court, case number 0C4/2023. It's only 9 paragraphs. We refer to the above matter and confirm that we remain the attorneys of record of Mr. THABO Bester. We have over the past month been trying to obtain a date for hearing of the notice of application. In our last correspondence to you, we have specifically stated that the matter should be enrolled in the criminal court and not motion court, in that the criminal court hearing the matter is best placed to determine the jurisdiction. Because you come to a court, and if the court has issue with jurisdiction, it determines its own jurisdiction. It doesn't refer you to another court. You have also gone back in your email of 25 September 2024, directing the matter to be enrolled in the motion court. This is according to your email after remarks by the judge president that this matter is a criminal matter but must be enrolled in the motion court. We accept this as only the remarks and not the order by the judge president. We wish to remind you that we have not made any request to have this matter enrolled in the motion court. We have already placed it on record that the notice of application would be moved in the criminal court. It is for the judge in the criminal court to determine the jurisdiction. After hearing arguments, the registrar cannot purport to make a judicial pronouncement. As you are aware, the criminal trial has already been set down.
Mr. Miela, I get the gist of what you are saying.
Yes,
but then you have not answered my question. Where is the prosecutor here? Whom did you serve? Because none of the parties have been served here.
My lady, you have opponents. They are representing the respondent. All the respondents that are cited are represented today.
Mr. Muyela, were all these people served in terms of what the rules prescribe? How were they served?
My lady, and that is the question of jurisdiction. Your lady, and this is the problem that I foresaw by us being brought to this to this motion court. You have a matter in a criminal court that is not straight-jacketed to any process in the civil proceedings. Then you are taken out of that proceedings. Then you are brought to a proceedings, and your ladyship, if we venture into that, your ladyship would be crossing the bounds upon which this matter was directed. Your ladyship was asked to do one thing, to determine whether this matter is a civil or criminal, not any other thing. So if today I'm asked to answer any other question, whether there's been a service or not, that is not the question that...
But how do you bring people to court, Mr. Mueller? Because that's the first step of bringing people before court.
If that was the issue, my lady, this was not going to be the directive from... Firstly, your ladyship...
but Mr. Mueller, I'm saying, the first step of bringing people to court is notifying them that I want you to come to court with me.
And they're here.
To come and present. Who is here?
All the respondents that we've cited.
Who are the respondents that you cited?
The state.
Who is the state?
The state is the prosecutor.
No, Mr. Mueller.
I'm saying the state is represented, I mean the state is represented by the prosecutor. And that's what
Who is the prosecutor here?
It's the NPA.
Where are they?
They're represented by the state. They're represented by the state. That's a simple answer. The state...
Mr. Mueller, a lot still has to be done here.
Yeah, my lady,
I think where we are, you are losing even the fundamentals here. Yeah. The simplest, the elementary steps in
my lady, truly speaking, I can't lose the fundamental when your ladyship does not allow me to finish any point. And that's where we are going now. Because your ladyship will ask a question, and I say, this question itself.
But when I ask you a question, you do not answer the question that I ask, Mr. Mueller. You keep on going beyond what I'm asking you. You are not answering the question.
Okay, let me answer it and then we'll motivate. We are here because the judge president issued a directive that a civil court must determine whether this is a criminal or civil matter. So that's a question before your leadership.
Yes. You are now before a civil court.
Yes. Yes,
you are before a civil court.
Yes.
What brings you before a civil court? What is the first step that lands you in a civil court, Mr.
We are brought by a directive. We are brought by... There's nothing that we should do further than that. We are brought by a directive. We are brought by a directive, my lady. I can't take this argument further than that because this matter is in the criminal court. The criminal court has not dismissed it. Has not dismissed the issue of jurisdiction. In fact, ordinarily, the judge should have decided, but because he's already made certain comments about the competency and not an order, he simply says, on the 22nd of October, I'm going to allocate a judge specifically. There's no way that we are going to come here with a directive and we must meet any other requirement other than what the directive requested. This is what it says. On the 21st of October, after that email that I was reading where we were requesting the date in a criminal court, this is what the office of the registrar coming from the judge. So
you're telling me the judge president's directives went beyond what the rules of the court prescribe?
No, that's not what I'm saying. What I'm saying.
So what are you saying? What are you telling me?
Is going beyond the directive, vice versa, not the other way. Your ladyship is going beyond the directive. The directive directed specifically that your ladyship should determine whether this matter is...
And I am the civil court.
Yes.
And there are certain procedures that must be followed for you to knock at my door and say, here I am. I am that court. But before you start addressing me, you start standing there. There should be certain procedures that you must comply with, which have not been complied with, Mr. Muyela.
My lady,
unless you're telling me that the JP told you not to comply with what the rules say, then unless you're trying to tell me that, there are rules that govern any court, Mr. Muyela.
I'm going to tell you what the JP has said. Can I read what the email from the Office of the Registrar said? Because every time I try to make a point, there's an interjection, the point is lost. And that's what has been happening since morning. Try to make a point, the point is interjected, and then I'm driven to another point. I've hardly been given an opportunity to present
Mr. Muyela, I gave you an opportunity over and over again. And every time I'm giving you an opportunity, you deviate.
I'm not deviating, my lady.
And take a route that does not deal with what I'm asking you, Mr. Muyela.
I'm going to answer for the last time. I'm saying that
you only have to answer many times because I'm going to ask you many questions, Mr. Muyela.
Yeah, I'm talking about this question. I want to get any further. Because I answered and then I want to motivate. And I'm told that I'm deviating with the motivation. Firstly, we are here because the judge president directed, allocated us a judge.
That is why I made a follow. That is why I made a follow up. No, your basic point is, you saying the judge president brought you here, brought you before a civil court. And my question was, because the judge president said you must go to a civil court, for a civil court to determine what you are bringing before that civil court,
no,
there's certain rules that need to be complied with.
No, and exactly that's what we are differing. And that's why I'm saying that this point, if this point is not taking me home, I want to stress further than that. But nonetheless, there are a plethora of cases that I will also rely on. And I hope that reliance on the case law won't be a deviation. Because if I make a point, I must amplify it either through explanation or case law. And I'm going to beg your ladyship to be patient with me when I make a point and I want to refer to the case law. Firstly, and this is the email that I'm trying to read, and I've not even read one sentence.
Okay, proceed.
It says that, dear madam, this is a response from the ATIM. When we were, that letter that I was interrupted reading, in summary, it says that allocates us a criminal court. And the judge president responded, I will allocate you. Then we then say that we are waiting for that date. And then we were accused that we misconstrued the email because it was not disclosed which court. Then this is the clarification of that sort of what was called misunderstanding. The email was indeed incorrectly interpreted. The email was stating that you must agree on the dates for presentation of argument on whether the matter is civil or criminal in nature. So we are doing two things: agree on the date and present the argument on that date, whether this is civil or criminal matter. This is in a civil court before any other judge than the JP. If you can provide dates, then it ends there. So now, when you look at this chain, there was also an email on the 8th where the judge president said, I will allocate a judge specifically to deal with this. So we allocated a judge. Now, I must start afresh as if I'm issuing an application. When the application is already issued at the criminal court, when the application has already been served on everyone, when everyone has already filed an answering affidavit, when everyone has already filed even their heads, and now, if this indeed what your ladyship is saying in terms of the citation of the parties, Mukesi, I wanted to tell the parties in that Mukesi case, your ladyship stopped me. The parties in Mukesi is the accused and the state. None of that which your ladyship is raising arose in Mukesi. You want to see in the citation the NPA. And this application has been served on the NPA. In fact, the state is served on the NPA.
And that's the reason that application was dismissed.
No, that's not
because
the reason.
You're saying some of the comments was that the comment that you are relying on at this point was that they approached the wrong court to ventilate this issue.
Section 35, right?
Which
yes. That's what...
That's to ventilate, no. The issue that they were dealing it was implicating NPA directly. There were no other external parties that are not linked at all to the business of the NPA, because their complaint was mainly confined to the charges against them. Here, we are not dealing with the content of what the charge is against the accused, against the applicant. We are not dealing with any of the issues that were raised in Mkhesi. You are dealing with the treatment of external stakeholders that are not a party to a criminal case. I hope you understand. The National Commissioner of Correctional Services is not a party in a criminal case. The head of Center of Khosimampudu Correctional Services Center is not a party in the criminal case. The Minister of Correctional Services is not a party in a criminal case. Not only that, look at how the prayers are, the applicant's prayers are structured here. Firstly, is to declare the conduct of second and/or third respondents in refusing the applicant's meaningful legal consultation in preparation of his matter between State versus Magutuman and others to be unconstitutional and invalid. You tell me if that issue can be determined in terms of the Criminal Procedure Act. What brings you tell me if this can be determined in terms of the Criminal Procedure Act.
Section 73, Malini, deals about legal representation that must be meaningful. That deals specifically
Mr. Muyela, you seem not to be hearing yourself. I'm saying you want a declarator. You want me to declare conduct of correctional. And
that's what your ladyship is missing the point. Your ladyship is not invited to determine the prayers.
No, I'm saying, no, you are saying before I can determine whether this is a criminal or a civil case, what determines whether this matter has to be heard by a criminal or a civil case is the prayers that you are bringing before the court. The prayers that you are bringing before the court will then determine. Yes. And you think, in your argument, declaring the conduct of the second and third respondents in refusing the applicant meaningful legal consultation in preparation of his matter is a matter to be decided by a criminal court?
Yes, I'm going to answer that. And to the extent that I'll be again accused of deviating. In paragraph 9 of our heads of argument, we rely on the case of Mukheti. It says converse what your ladyship has said. Your ladyship has just said that the nature of the proceedings determined by the notice of motion. And this is an appellate division, and it has not been set aside. It says conversely to what your ladyship had said. I'm going to read it verbatim. It's paragraph 9 of our heads. It's the case of Sita. Your ladyship will go to paragraph 9 of our heads. We've quoted it verbatim. It says converse to what has been said here. This is what it says. At page 449A to E of that Sita case. Full citation is at paragraph 9 of the heads. This I'm going to read it verbatim. Open quote. The mere fact that the proceedings in the court are were fresh proceedings instituted by way of a notice of motion does not give to those proceedings the character of a civil nature. And it goes further. It is, in my view, not the form of the procedure adopted, but the subject matter of the proceeding which determines their character as either civil or criminal. Then this is what
but what is the subject matter, just on that point? What is the subject matter of these proceedings?
The fair trial subject matter. Legal representation. Case law will tell you, my lady. But my lady,
I'm not going to interrupt you anymore. Proceed with what you are saying.
Yes.
Please proceed.
So this is that what it says. In terms of the comment that was passed by the court. Now, in my view, does the fact that the relief was sought by a way of declaratory order, that's what we said, interdict or mandamus, make the proceedings before the court a civil matter. So exactly what this case is converse to what your ladyship even those declaratory order does not determine the nature of the proceedings. You determine the nature of proceedings because of the complaint, nature of complaints. So what is the complaint? Let's forget about the ancillary complaint.
And what was the complaint in that matter? In that matter, that specific matter, what was the complaint?
The complaint was, this was a review proceedings from the magistrate court. And then it was taken to the High Court. So now, the objection was that this is a civil matter because there's a notice of motion, because there's a mandamus. The case law is answering to that. That does not lend any assistance to that. And further to this case, the case that I started with, that's Van Rooyen. It also deals with the issue that your ladyship has raised, the issue of citation. In that case, it was before a criminal court, correctional service was cited, minister of police was cited. And I'm going to take your ladyship to the full citation and full words, in the words of the presiding officer. Because I think it's easy when this case law speak for me, because they answer all these questions that your ladyship has asked. So now, my argument, and there's also a case of the Constitutional Court, in the case of, we relied on paragraph 11 of the head. That's a Shabalala case. It literally just confirmed what was said in CETA, in a sense that it was commenced with the notice of motion in the High Court, and there was nothing wrong with that. So it's not that the procedure adopted is not the prior that we have determined. And now, extensively, to the extent that these cases do not extensively explain what I've said, I'm going to take your ladyship to our heads of argument, wherein we quoted the Van Rooyen case, wherein the parties there were correctional service, and in fact, Van Rooyen was cited in the manner that we did. In Van Rooyen, it's a lengthy quotation. I'm just going to the heads. You will find Van Rooyen at paragraph 13. Paragraph 13. This I'm going to ask your ladyship to allow me to read this because it's going to answer everything. The rules
proceed, Mr. Mayor.
Yes. Paragraph 13 of our heads of argument. We cite the case of Van Rooyen versus Department of Correctional Service and INRI S versus Dutoy. That's what we did here. We cited and we say INRI S versus Maguduman and others. So in that matter, which we say it's in all force, this is what the court says. This is an application in terms of section 38 of the Constitution. That was in a criminal court. As will be indicated below, the jurisprudence indicate that there's no restriction placed on the way in which person can approach a court in terms of section 38. That's our notice of motion as well. The argument on behalf of the first respondent that the provisions of 612 were not complied with because there was no notice of motion with supporting affidavit does not stand up in my opinion. Either, first, Rule 612 authorizes a court to dispense with the forms and meaning prescribed by the rules. More important, however, is the fact that, in my opinion, the argument on behalf of the first respondent does not take into account that this is an application in terms of section 38 of the Constitution. The question arises whether the motion procedure is applicable in a case like this. What your ladyship was saying, that you must follow all the rules of motion procedure. Should every defendant who, during a course of his criminal case, believe that his or her fundamental rights are being violated, or that there is an imminent violation of such a fundamental right, ask the trial court to be suspended first in order to approach the motion court. In my opinion, none of these enshrined in section 35(3) of the Constitution necessarily lend themselves to the introduction of motion proceedings. It says that if an accused's rights are violated during his trial, and the violation directly impacts on the question of whether his trial is fair or not, the designated forum is the trial court. The question arises whether even an unsophisticated accused who appears in person in a small country town but falls in love with a violation of Article 35, it's referring to Section 35, and whether he is obliged to first go to motion court in accordance with the provisions of that uniform rules to enforce his rights. Secondly, the trial court in which the criminal case is conducted is the forum, and this is what it says, not just the forum, is the forum par excellence to which he must run. What happened? Mr. Bester ran to that court, which is, in terms of this case, is the par excellence. It is clear that the multitude of situations can arise and that a person's constitutional right can be infringed upon in every possible way. This can be done by individuals, correctional service, administrative officers, and bodies, tribunals, all of the kinds, and even court itself, when the court allows an accused to be changed. In each case, the court dispute will be whether the relevant right has been infringed. The Constitution has created a special mechanism, and it's clearly not limited to common law review, although it may include it. It is clear that the court has the widest possible powers, and that's the criminal court, and competence within the framework of the Constitution to ensure that the person's constitutional rights are not infringed upon, and if it has already occurred, rectify. We know which court they are talking about. It is clear from the aforementioned jurisprudence that, in my view, that the enforcement of rights may only take place in terms of provision of section 38 of the Constitution after being placed in a procedural straitjacket is inappropriate. Section 38 places no procedural restriction on any applicant as to how he must place an application before the court. So this case is loaded with the answers, is loaded with the solutions in terms of each and every reservation, not only raised in that criminal court, but raised in this court.
Mr. Muyala, while at it, do you know what the issue was in CETA and Another versus Olivier?
Yeah, it was a review from the magistrate to the High Court.
No.
My lady, we relied on that case in the...
Let me tell you what it was. The accused appeared before a regional magistrate. And when they were before a regional magistrate, they refused to plead, demanding that their matter must be taken to a superior court. And they then came to a superior court on a notice of motion,
yes,
to request that court to have their matter heard by a superior court.
Yeah, firstly, it was review and set aside. They wanted to review and set aside that of which the magistrate has refused. So that's why the point that I concentrated on.
What I'm trying to warn you and try to bring to your attention is that all these cases that you are quoting have got in their the facts in those cases have got nothing to do with the issues raised by the applicant here. They are squarely, the courts there said, it matters not that you would bring your application by way of notice of motion. This has to be dealt with in the court that it has to deal with. You cannot, as the accused, demand that, or choose a forum that would have to hear your matter. So you understand that the matter there, that specific case that you rely on, Olivier, also that matter deals with the proceedings themselves in the magistrate court. This specific accused did not want to plead before a magistrate. They wanted their matter transferred to a higher court.
Yes,
that's not what we are dealing with here.
But my lady, your ladyship, literally when I went to CETA, it was direct to the question asked by your ladyship, and I'll go back. Your ladyship says that let's go to your notice of motion. And your ladyship says specifically, the notice of motion will determine whether this is civil or criminal. Can I just finish? And then your ladyship...
But CETA, the notice of motion in CETA itself, what they were requesting in CETA was not what you are requesting here.
But my lady, the paragraph that I quoted there says the notice of motion does not determine the nature of the proceeding. Is that not a principle? That's a legal principle. It applies everywhere. You won't find cases in every instance that you don't apply the law through the facts. You apply the law through the principle. So that's why when we say follow the principle, we are not following the facts. What is the principle in CETA in respect of the question that the ladyship has asked? Is that the notice of motion does not determine the nature of the proceedings. The prayer does not determine the notice of the... That's what CETA said. That's a principle. Your ladyship want us to leave the principle and go to the facts. We are not here to resolve the facts of CETA. CETA has already had a judgment.
Before you apply any principle, any legal principle, you must also ask yourself if it is the issues in that specific matter are relevant are relevant to the case in question, or do they relate to what is at hand. That's if the facts are distinguishable, then you cannot apply that principle.
No, this I'm going to answer in two ways. One, when you want to say the facts are distinguishable, you try to avoid the outcome and not the principle. You avoid the outcome. So in other words, I can say that the principle in CETA, this is the principle and this is the outcome. And then my opponent can say that no, but in CETA, they reach that outcome because of the facts, and the facts are distinguishable. But CETA set a principle. What is the legal principle there? The legal principle answers the question. Your ladyship says as a matter of legal principle and not as a matter of fact, because that's not a fact, it's a principle. Your ladyship says that the notice of motion, if the comment by the ladyship find expressing in the judgment, is going to be a legal principle and not a legal fact. So the legal principle is what is applied in proceedings. If you want to deviate, if I'm saying that also reach the outcome reached in CETA, then one can say that the facts are distinguishable. But we are not saying that reach what was reached in CETA. We are saying that apply the principle that was applied in CETA. What is the principle? The principle is that the notice of motion does not determine the nature of the proceedings. The prayers does not determine the nature of the proceedings. It's the subject matter. What is the subject matter? Is the complaint. What is the complaint? The first complaint that the applicant was complaining about. He has a plethora of complaints, and in that spectrum, he divided them. Firstly, legal representation. It's protected in terms of the legal representation, meaningful. It's protected in terms of Section 35. And also, it's given expression in terms of Section 73 of the Criminal Procedure Act. And then he then complains about other...
But I don't know about legal representation here, Mr. You are not saying that Mr. Bester is being denied legal representation.
We're saying meaningful. That's why it's very
you
important. Meaningful legal representation, because that's what the Constitution guarantees. The Constitution does not guarantee abstract legal representation. You've been granted an opportunity to consult. That consultation must be meaningful, and that's why we are careful with the words. It's very important to concentrate on the application, what it says, and not what it does not say. The application says that I've not been able to consult meaningfully, and then for the purpose of jurisdiction, you must accept that that's a fact. Because you don't have to then go to the merits and say that no, but the correctional service have refuted that. That is the substantive merits. For the purpose of jurisdiction, if I say that, if Mr. Bester is in his founding affidavit, of which he did, I've not had an opportunity to consult meaningfully, and he explained, what do you mean by that proposition? He says that I have a trial that needs to commence. I'm given 2 hours to consult on arrangement. And my legal representation, when they go to court, they are not allowed the device to enter with the device in that consultation. And there are video footages that are going to be used by the state that have already been exchanged. I need to see them with my legal representation. I'm also not allowed to have my own device to also consider the evidence, that is video footages and other images. And certainly when we consult in a manner that possibly violates the privacy. We consult through a glass window wherein Mr. Bester is sitting there. If your ladyship was with Mr. Bester, then we'll be separated by a glass window. And then your ladyship will be talking through a phone. It says that I cannot disclose without reasonable apprehension that this is tapped or someone is listening to it. So once he mentioned that complaint, what is the complaint? The complaint is that the violation of that right to a meaningful legal representation is the violation of Section 35. Because all the cases...
Thank you, Mr. Mielo. Can proceed to something else.
Yeah, that is one aspect. So I'm glad that that point is made. So now, to make my argument, because I was answering to your ladyship comments and reservations. So how I had structured my argument so that there could be some chronology, so that I can make my arguments properly. I structured it in 4 aspects. The first aspect, some of them are answered, and if they are answered, I will just quickly skip that particular aspect that has already been answered. The first aspect was how we got here. The second aspect, why are we
You've
here?
already answered that one.
Yes, yes. I'm just giving this structure, and then I continue. That's why I said if we have passed, I will.
You have passed that one.
Yes.
I've heard
And
that.
then we have why are we here, and then we have why we should not be here. That's the structure that I have. These 3 are going to answer everything. So the first one I've already argued. It's not even an argument, it's a fact that we were brought here at the insistence of the judge president for the matter for this court to determine a simple issue. And that's common cause between the parties, even in their heads, that we are here to determine this aspect. They didn't even raise all this procedure that we would not have been subjected to in a criminal court. So now the second aspect is then why we are here. We say that we are here because we are going to argue that this matter should be prosecuted in a criminal court. Then, on what basis? We say it emanates from the criminal proceedings where the applicant is facing several counts or charges. The trial is set to commence on the 10th of February. The trial right must be conducted in line with the dictates of Section 35 of the Constitution, as fleshed out in the Criminal Procedure Act. So, Section 35 is given effect extensively by the Criminal Procedure Act. When the Criminal Procedure Act prescribed what in Mukesi complain about, it's giving effect. Because you can't run a fair trial without the charge that is explicit and it's not falling short of what is required. So once you pick that, you're complaining about Section 35, but you are fetching it from Section 84 or 85. So that is the sum total of Mukesi. Then we say that in order to determine jurisdiction, I've dealt with that. We look at the pleaded case. What is the Mr. Bester's pleaded case? Mr. Bester's pleaded case is that he has no meaningful consultation. So when the trial starts, there's a reasonable apprehension that he won't get a fair trial. It's been, in fact, they've been violated now. Secondly, he says that access to necessary gadgets to consult, and he justifies that. There are video footages. He needs to have that device. We need to go to the consultation and view that device together. Thirdly, he says that the environment itself is inhuman and it's not conducive to prepare for a trial, because you need to have your mental state intact for you to come to a trial. That's why if I was an accused here and I'm showing signs of fatigue or disturbance, your ladyship would simply stop the proceedings so that the accused can bring his mind intact. So if you torture a person, we've dealt with that in our heads. If you torture a person, it will result in him being affected mentally. Then we then say that to be chained in court can create an impression before the presiding officer, who has no information whatsoever that this is a dangerous person. And it violates, as the case law that we're going to deal with, the presumption of innocence. So these are the real complaints. I've not heard anyone. When I was in the criminal court, all these things were avoided to rush to the ancillary things. Then we then say that now he must be treated equally like any other accused. Why do we bring all these other rights, despite the fact that we are home in the legal representation and the provision of gazette? We bring them because of our jurisprudence allows a presiding officer to adopt an intersectional analysis. One right can result in the violation of the other right. As I've just said, the torture of someone's mentally can result in his right to a fair trial being affected, because he won't be able to attend this trial with the mind intact. Then we say that, one, we dealt with this case of CETA. It's not the notice of motion that prescribed. And then I'll take your ladyship to paragraph 18 of our heads, where we rely on the case of S versus Zuma. The full citation is there in our heads. What is the effect of that? The case of S versus Zuma, this is in a criminal trial. In a criminal trial, This is what it says. Paragraph 19 and 20 reads as follows. We only paraphrase it in our heads. Because in our heads we say that the criminal court adjudicated a dispute prosecuted in terms of a notice of application supported by a founding affidavit where the accused sought to invoke Section 35 right Constitution by asking for a declaratory relief, and they prosecuted it, and this is what they said. It was justice school. At paragraph 19, and he even referred it as agent application, and it was not agent application in terms of Rule 612 because it was in the criminal court, and that's what they did. In the agent application lodged on Saturday, Mr. Zuma claimed the following relief, declaring that the trial of the accused plea on the virtual platform is inconsistent with the rights of the accused in Section 35, Section 3 of the Constitution. The trial, that the trial and other related proceedings between the state and Jacob Zuma, between the state and Jacob Gezelisekisa Zuma and another are adjourned in terms of the provision of Section 168 of the Criminal Procedure Act, to a date to be arranged and agreed between the parties, or the date to be determined by the Honorable Court. And this is what Justice Kun then said on paragraph 20. On 19 July 2021, I had argument regarding adjournment. So the adjournment is the first.
And you are aware that all these things that you are raising,
yes,
they implicate the proceedings in the criminal court.
Yes.
That it was about this postponement of his case in the criminal court. They all relate to that.
Yes. Can I explain, Malini? So this is what, in fact, it does not only, the gist of that is not mere postponement. So what happened in that case? The state, represented by the NPA, and there's a citation there, there's nothing wrong with what we've cited here. The state, as represented by the NPA, wanted
it is cited in that manner because the proceedings were before the criminal court at that point.
Mukesi is in the civil court, is cited in the civil manner, so there's no distinction. But I don't want to go back, because the citation in Mukesi is exactly what we did. We added other people that are involved. In Mukesi, obviously, it was charged. It's only the NPA. That's why, otherwise, Mukesi should have cited NPA, because the NPA that prepared the charges, but there's no NPA there. So this argument, this proposition. Then now, the point in S versus Zuma is this. They wanted to postpone, the NPA wanted to postpone the criminal proceedings virtually. Mr. Zuma insisted that I must be there. I must be there. So when they wanted to do that, he then approached the court.
And you understand that this was playing itself out within the in the criminal court, within that criminal court. Yes. It was about the postponement of that particular criminal case.
Yes.
And
he was
you
not
understand
taken out to a civil court because he come with a... remember, your leadership should not forget the context. We were taken here. We were taken... There's an impression that is being created here, as if like we came out of our own volition. No, we didn't come out of our... We did what Mr. Zuma did. We did what Van Rooyen did. We did what Shabalala case did when in the Kotakwa. The citation that would lie in the Constitutional Court, because paragraph 1 says that in the Kotakwa, this is what the accused were asking in terms of the notice of motion in the criminal court. We did the, even in Detroit. In Detroit, actually, it was about the legal aid. They did the same thing that we're doing, that we can't proceed without a legal representation. And the legal aid was saying that we need to review our decision. And the court answered that question that that's not always the case. Section 35 is there. It's not barred by the fact that there's another remedy that you can review. But we should not miss the point here. Mr. Zuma was not taken by the judge directive to the civil court. Detroit was not taken by a directive to a civil court. Van Rooyen was not taken from a criminal court. We have never, in fact, we objected to coming here.
Mr. Mayala, I do not think, I now understand that whatever I say will never really make sense to you. Please proceed to something else.
Yes.
Proceed to something else.
I've just spoken, because what we are doing here, we are looking at whether, in fact, what we should even visualize here is that we should see ourselves in a criminal court arguing the jurisdiction of the criminal court. The criminal court would have determined that jurisdiction, either granted or dismissed, and not bring other straight-jacketed procedures. Then the third point, because now the why we are here I've answered, and why we should not be here is the next point why we should not be here. We say that in paragraph 17 of our heads, and that's a case of Moyo, that's the SCA case. We've quoted verbatim what Moyo says. Moyo says the following. I'm going to rely on 157 and 167 of Moyo. It appears at paragraph 17 of our heads. It says the following. 157. In section 35 of the Constitution guarantees a range of rights to arrested, detained, and accused person. Section 35(3) guarantees to all accused persons the right to a fair trial. This is secured in practice by Criminal Procedure Act, because you enjoy that through Criminal Procedure Act. The application of the Criminal Procedure Act is to ensure that you have a fair trial. Then, this is what it says further. The appellants do not seek to impugn the provisions of the CPA in any way, yet they are seeking to assert their right to a fair trial before a civil court. It's quite complaining about the same thing that we wanted to complain in the criminal court. And it continues. This should give pause for thought. Why the issues germane only in the context of criminal proceedings being canvassed? Why are we even here? Canvassed and determined in civil proceedings and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for the adjudication of the criminal case. And then 167 says that as a general rule, departures from the procedures laid down in the Criminal Procedure Act and the effective removal of criminal proceedings to the civil court should not be countenanced. The import of what was said there, even though it's self-explanatory, the fundamental basis is Section 35. Section 35 can be violated in a range of ways. Obviously, your ladyship keeps on bringing the Mukesi that is 84, but is violation of Section 35 only happen when Section 84 of the criminal procedure is violated? No, even Section 73, which guarantees that a person must have a legal representation which is meaningful, and we complain that is not meaningful, which means that the criminal court can determine that particular dispute. So now we find our situation where when we follow the right procedure, we are taken to a wrong court, and we must justify ourselves in an instance that we are not here at our own instance. Actually, that will not only be injustice, it will be a miscarriage of justice. It will create an impression that certain litigants, when they raise Section 35, are going to be given directive to go to a civil motion. When it goes to a civil motion, they are trapped. You didn't comply with Rule 6, you didn't comply. All these other things that any other accused are not subjected to. As Van Rooyen discarded all of these things, all these objections Van Rooyen discarded in the most strongest terms. Discarded Rule 612, discarded the notice of motion. In fact, in criminal proceedings, I can even stand and complaints from the bar. Application in terms of the criminal procedure does not mean application in terms of the uniform rules. That's a distinction that needs to be understood. That's a fundamental, it's a basic principle.
Which section of Criminal Procedure Act did you bring this application?
In terms of the legal representation, is Section 73. It impacts Section 73. And all others are subsumed in terms of Section 35. That's the interrelation. So legal representation is Section 73 of the Criminal Procedure Act. That says that you must have a meaningful legal representation. So the violation of that section itself violates Section 35. That's why in Moyo, it starts by the fundamental basis of Section 35. And it says that when the criminal procedure is running, you look at the criminal proceedings through the prisms of Section 35. So you must accept that that complaint is good for the purpose of jurisdiction. Even if we can then, correctional service can have a justification. That will be the court that will determine the merits. Your ladyship is not invited to determine the merit. Then, we then say that then the issue of Mukesi I've dealt with, and I really don't understand why Mukesi is being missed when I read exactly the verbatim of what Mukesi did. Mukesi says that these people are complaining about their fair trial rights. The fair trial rights happen in a myriad of ways. So in that way, context, it happened in Section 84. Does it mean that only Section 84 can impact on Section 35? No. So that one I won't repeat again, because Mukesi, that's exactly what it says. This includes constitutional challenges to charges or allegations that an accused person's fair trial rights guaranteed in Section 35 would have been infringed. So it's not a Section 34 in abstract. It's looked within the prism of Section 35. We take Section 73, look it at the prism of Section 35. We take the issue of torture, you look it at that with other provision in the Constitution. The question that you would ask yourself is that, is this conduct going to impact the fair trial right? And the court that is going to determine the substantive merit will make that finding. But for the purpose of jurisdiction, you must accept that indeed is going to make that particular aspect. Then we say that now, in conclusion, because a lot of things I've dealt with, then I can't repeat myself. This case has been well pleaded. The court is invited, not through the applicant's own volition, through the directive, to determine whether this is a civil or a criminal matter. And in all these cases, they support the proposition that this is a criminal matter. If it's a criminal matter, that's the end of the case.
I do not know. I haven't found what you are saying in all of these cases that you are quoting, that this case has characteristics of a criminal matter. Because even in the matter of Moyo that you've just quoted, the issue in Moyo was the challenge, the
constitutionality.
Accused were challenging the constitutionality of Section 1, subsection 2 of the Intimidation Act 72 of 1982, which this was basically in relation to the charge that they were facing at the time, and they were challenging the constitutionality of that section that brought about the charges that they were facing before the regional magistrate. And still here, it was all about the charge that they were facing in that court. But then I'm not going to let you go off again.
No,
I listened to you.
Yeah, but
I heard what you were saying.
Because legal practitioners are not magicians. They can only make legal arguments and they can take it further than that. The point is that, in fact, that case itself commenced in the magistrate court, and they took it to a high court in a civil court. So these words that were said by why is this matter that's supposed to be in a criminal court is in a civil court. And then the counter argument was that the magistrate does not have competence to declare legislation unconstitutional. And it was answered. It's not a justification of bringing a matter which is criminal in nature, arising from a criminal proceeding, to a civil court. It even said you could have arranged with the NDPP to place it in the criminal court, in the high court. So it was not a justification, but this is the catch.
But it still differs from the matter that you are bringing here, Mr.
But we're talking about what is the principle. The matter is a criminal matter, must be held in a criminal court.
Thank you, Mr.
Yes, that's all I'm saying. I can't take it further than that.
Do you have something else to say?
No, I was summing my argument and then moving to that point. So now, once you accept that the criminal matter, it matters not your own reservations. It matters not your own preconceptions. It matters not what you think should have happened. The question that you are invited to answer, it's simple. Is this a criminal matter or a civil nature? And once you say it's a criminal matter, and it is the characteristics of all that looking at them from the principle, then this matter must be heard in a criminal court. That is my submission.
Thank you, Mr. Miela.
Thank you, my lady.
Mr. Sniranda.
Well, you've clearly read the age of argument, and we do not intend to repeat the age of argument. We respectfully submit, my lady, that Sita, Van Rooyen, Mkesi, Ojo, all those cases didn't related to matters strictly within the CPA. When you look at the facts, and that's where we determine what the case is about. And Mkesi was, as my lady correctly pointed out, a challenge, and also related to admissibility, which is stuff that the criminal court needs to adjudicate. But this matter is distinctly different, because firstly, it transcends the parties in a criminal trial. There's only one prayer out of all the prayers where the first respondent, which is cited as the state, is involved. All the other relief that's sought is only sought against the second and third defendants, respondents. If you look at the notice of motion. So the first prayer, my lady, that you'll find that any other respondent is, relief is sought against any other respondents actually on prayer 7. Up to there, the complaint is about the second and third respondents. We know the second and third respondents are not parties in the criminal case. It's the National Commissioner of Correctional Services and the head of a centre where Mr. BESTER'S is kept, mpofu-walsh. Then, we look at the relief that you ask, which is the point I think my lady was making when we read Sita and Van Rooyen and all those cases. We have to determine what you are asking the court for. This matter, for instance, Mr. Bester asked an interdict. He asked an interim interdict. He actually deals with the requirements of an interdict. And he asked cost. Now, the only provision that we are aware of and we speak under correction, where costs is mentioned in the CPA is 3428. And that's where there's unreasonable delay. There's no other provision in the CPA that would relate to costs. But no matter, we can make it, actually we can make it short and sweet. We don't have an issue with what the court said in Sita with regards to substance over form. You're in a criminal matter and you want to bring an application and you use a notice of motion with founding affidavit, doesn't certainly turn it into a civil application. We understand that. But what the full courts have in the meantime said, and now my lady is obviously sitting as a single judge in the Free State, not bound by decisions in other divisions, not even full court decisions, but they do have persuasive power. And we have referred, my lady, to 3 full court judgments, 2 of which, all 3 involve Mr. Zuma. 2 in the Gauteng, Johannesburg Division 1 in Natal. And you'll find references from paragraph 22 of our heads. The first one that we've got there is President of the Republic of South Africa versus Zuma. But what we submit with respect is when you look at the case in paragraph 24, that's President of the Republic versus Zuma 2023-1. This is the positive of the arguments that you've been listening to. We've quoted the relevant passage to you. Since the proposition has been affirmed in the constitutional era, because this is what's important, and then the judge lists a number of cases, he says it's therefore plain that upon such authority, section 106H of the CPA, and the facts of that matter cannot be construed to be the exclusive route by which a person aggrieved by private prosecution can challenge the title of a private prosecutor. But this is where the relevant part starts. Moreover, the proposition advanced about avoiding cross-contamination between civil courts and civil process and the criminal courts and criminal process is overstated. In truth, there is no substantive distinction between criminal court and civil court. There is only one court, and the streaming of criminal cases and civil cases to different judges is an organizational convenience. In this matter, looking at the form of a relief that is sought, looking at the parties, the Judge President said, directed that this matter must be heard by the civil court, which he's allowed to do. The question is, Mr. THABO argues it should only be heard in the criminal court. We say that is wrong, and the Van Rooyen case out of the Transvaal is in any event overtaken by the full court judgments in that division. We go on to say there is no distinct jurisdictional competencies, and similarly therefore it follows that the process of such a court is also seamless. No question can arise of trespass into the work of another court with a distinct jurisdiction. It is in these respects that the present case does not evoke the suspicion posed by Wallace, J.A. and Mojo and so on. So, Mokesi Moyo, all those cases dealt with matters strictly within the CPA. So it resorted in the criminal court. There was no argument, there was no problem with it, no issue. This matter is also in the civil court. There can also be no problem. This is the court that should hear this matter, because what the court is asked to do is to compel, and it doesn't matter whether Mr. Bester frames his relief to bring it back to fair trial rights, because it also implicates rights in terms of section 9, 10 and 12. But it involves his conditions that he's kept in prison and what is happening there. And the relief he seeks is against those parties. We respectfully submit there can be absolutely no doubt that this court, the civil court, has jurisdiction and is probably the suitable court, the only suitable court to adjudicate this matter. We doubt very much that Mr. Besser, if he succeeds with his relief, does not want costs. Well, he won't get that in the criminal court, because relief that he seeks in that event is in any event not competent in that court. So, in short and sweet, we look at the relief, but you not only at the manner in which you approach court, we have to look substantively at what you're asking court. Then we determine in which jurisdiction must we be. In this matter, there can be absolutely no debate. We should be in the civil court. And if there was any doubt, we respectfully submit that the three full bench judgments have put that, as taken that out the way completely. May I just take an instruction on that?
Thank you.
Yes, we've referred you in the heads, my lady. You would see to the Macadam judgment of the Constitutional Court. The only relevance of that judgment was simply that the Constitutional Court said that your constitutional right of access to courts, which are independent of other arms of government, is not a guarantee. Section 34 doesn't guarantee or include a guarantee that you've got the choice of procedure of forum. That's something. The access to court is governed by the rules of court, of course. So the fact that you are entitled to a right of access doesn't mean that dictates that you can say, I want to be in this court or I want to be in that court. The normal jurisdictional issues, of course, find application in that manner. Thank you, my lady. We respectfully submit, as far as the jurisdiction question is concerned, that is the civil court has, and is a suitable court to hear this matter. Insofar as cost is concerned, my colleague hasn't addressed you on cost, but if the court's minded at this stage to make a cost order, we will respectfully ask it to make it on the scale C and B, respectively.
Thank you, Mr. Snellenberg. Mr. Moyana, before you even proceed, when I asked you, where is NPA? Because you had so many issues raised in that process, you responded that the NPA is before court. The NPA is not here. The NPA is not here. Why? Because there was no service on the National Prosecuting Authority. In terms of what the rules prescribe. They are not here. And I asked you, that was my first question. You are not able to answer that, but I'm going to, for the last time before you reply, make you aware again that we do not have NPA here.
My lady, I've answered that question, but I'll give it a try again. But I've answered that question.
Where are they? Where are they? Where's NPA?
NPA, it represents the state in criminal
Yes,
proceedings.
where are they now? In these proceedings, where are they?
My lady, in criminal proceedings, the state is not a party. These are criminal proceedings. That's our proposition. We say that in criminal proceedings, the state is not a part. I mean, the national prosecution is not a party. It prosecutes on behalf of the state. That's why you never find one
that
state.
state that you have cited as the first respondent, where are they? Or where is the state?
They are representing all the respondents that we've cited.
No.
We can go to the notice. They are representing all the respondents that we've cited. I'm going to ask my attorney to just deal with the issue of the notice of opposition. That's why it's not even an issue, but my attorney is assisting me with the notice of opposition, which says that they represent the respondent. I'd want to also direct the court to paragraph 6 of the founding affidavit. Paragraph 6 of the founding affidavit. This is the citation. And in all proceedings, including the case, this is how it happened. The first respondent is the state, represented by the Director of National Prosecution, Bloemfontein, with its business address at Waterfall Center, and then all this address. In terms of Section 179, subsection 2 of the Constitution of the Republic of South Africa, read with Section 20, subsection 1 and 5 of the National Prosecuting Act, the prosecuting authority has the power to institute proceedings on behalf of the state and carry out the necessary functions incidental to the criminal proceedings. So when the NPA is in court, it's not there as a litigant. The NPA there is there to represent it. So it's the lawyer of the state, which it gets its power from 179 and then given expression in the NPA. That's how it is. But
you see,
and this is the notice of opposition I found with my link.
No.
And
why I keep on asking you that question is because you are saying these are criminal proceedings, and at the same time, when I ask you where is the prosecutor, you then tell me that the prosecutor cannot be here because we are in a civil court. You keep on saying that to me.
That I've never said. And
You've said that just now. You've said it just now, Mr. Muela.
No, my lady, that's not what I said. That means I must not have made that point clear. Then I would have to amplify it. But that's not what I said, and that's not what I've been saying.
No, it's fine. It's fine. I've heard the gist of what you are saying.
This is what I'm saying. Because I wanted to even show you, Lordship, that in terms of the site, in fact, the state is not an abstract thing. The state is set on the NPA. The NPA, when we're in the criminal proceedings, the NPA simply briefed. And because the NPA is the lawyer of the state in terms of Section 179, it's not a party to the criminal proceedings. Even the criminal proceedings, they are not there as the NPA, as a party. They are there to represent the state. So who are the parties in the criminal proceedings? It's not the NPA. It's the state versus the accused. And then the state is represented by the NPA. I'm not a party to that proceedings. I'm not an accused. But I represent... Thank you.
Proceed to something else,
yeah,
to your reply.
The notice of opposition, it says that all respondents, and then indeed it was served on the NPA. This application was actually served on the NPA, so they know about it. To the extent that they would have wanted to intervene and come or deal with the objection of non-joiner, which is obviously not supported by any case law whatsoever. They didn't do that, because obviously they wouldn't. But now, let me deal with my opponent's responses briefly. I've noted this point as 5 points. Firstly, let's go to the respondent answering affidavit at paragraph 59.2. This is where they answer the issue of jurisdiction. Any other person in this country accept that the criminal court has jurisdiction. It's the reservation when you appear in court and it appears for the first time that all of a sudden it doesn't have jurisdiction. When in their answering affidavit at paragraph 59.2, they take no issue.
Which page, Mr.?
The paginated page. I'm just using the one that is not paginated, but it's
direct me to the paginated pages, Mr.
I'm just going to ask. The paginated page, it's reflecting as 104 in the state's bundle. This was the response to the assertion that we've made in the founding papers that the criminal court, because we're in the criminal court when this affidavit was drafted, we say, I'm advised that the criminal court is well suited to hear complaints regarding infringement of a fair trial. It is actually the most suitable forum. And then we deal with section 38 that Van Rooyen supported.
Where are you reading, Mr.?
No, I'm just giving the content. I'm not reading yet. I'm just saying that before I give the answer to 59.2, I need to inform the court that it's the response to the allegation in the founding papers. So they don't dispute jurisdiction. So we pleaded jurisdiction at paragraph 14, that the criminal court, in terms of the complaints that we had brought there, it has jurisdiction, and this is what the state says. Not what the states now in their heads. Whilst the respondent do not take issue with the issue of jurisdiction of this court. This court, they were talking about the criminal court, because when these papers were filed in the criminal court to determine the appellant's complaint. That's it. So they don't have all complaints now. They all of a sudden we jump into the bandwagon because now the presiding officer are raising certain reservations. If you look at this pattern, everything that has been raised by this court became what was then transplanted into the heads of argument. It's not in their papers because they know they couldn't. But now it's easy to be opportunistic when certain things are raised that works against your opponent or as a reservation by the court. But what did they say in their papers? The complaints. Which complaints? All these complaints that this court and that court were focusing on, they say that they don't dispute. So if now we want to be so strict into this issue of procedure, this is then the 101 we speak about in law. You plead your case in the papers. So what did they plead? Did they object to jurisdiction? No. So now it can't be opportunistically now all of a sudden this matter is not a criminal matter when they in their own words they accepted. The first point that I wanted to deal, that the issue of jurisdiction is not born from the papers that they've pleaded. It's born from all this consistent reservation by different presiding officers. They find themselves in the heads of argument. We've been consistent what we've been saying. We said that in the founding affidavit. We said that in the reply. We said that in the heads of argument. We've never been opportunistic by hearing someone saying addressing a reservation and we jump into that bandwagon. We've been consistent in our allegations. Then now, the point 2. So it's the court itself that is challenging this jurisdiction, because if the court wants to determine, it must determine on the papers. So point 2, it says that this is not, despite the fact that they were said that it can be held in a criminal matter with all these citations, they said the respondents are not party to the criminal proceedings. Other respondent, because the state is the party to the criminal proceedings. And they said only prayer that is sought against the state is one. Does that disentitle the jurisdiction? Other prayers can fail. But does that disentitle the court hearing the matter if, on assumption that the state, there is a prayer against the state? That's one point. Secondly, the Van Rooyen case that everyone is trying to avoid. The first respondent was the correctional service, and it was held in the criminal court. They were complaining about this right. In fact, if I would even extend, in the Van Rooyen, the court even had to fashion new remedies that after court, for legal representation to be effective, you sit after hours and consult, because At prison, the situation was not conducive. Because the question is that, can he have a fair trial under those circumstances? Van Rooyen mediated that and came fashioned with the new relief that the court can do that. But that's a substantive merit. So that's one thing. What we did here was done in Van Rooyen. The court must then find something else, that find justification why correctional service was in Van Rooyen in the criminal court, why the SAPS was in Van Rooyen in the criminal court. There must be some special comment that the court must make, that this particular person, because there's an allegation that he escaped from prison and he was found in Tanzania, therefore we're going to deviate from Van Rooyen. Then, I want answer. I've dealt with the issue of prayers. My little colleague, when he starts, obviously then says that he does not say that CETA is wrong. In fact, there was a change of tone in terms of the heads of argument. In the heads of argument, it was addressed with passion that is the notice of motion that determines the nature of proceedings. But now in the oral submission, it was toned down a bit that the CETA is correct, but on the facts of this case, this is the civil proceeding. So you can see the shift of argument. The head of argument says one thing. Because a notice of motion was used, it's a civil procedure. Because there's a prayer of interdict, it's a civil procedure. Because there are other parties that should not ordinarily be part of the criminal proceedings, it's a criminal procedure. And that's what CETA answered. It does not matter. That's what Van Rooyen dealt with as well. That's what Van Dutoit dealt with as well. So now, in fact, in Dutoit, the legal aid was there. Is the legal aid part of the criminal proceedings? No. It was there. They were even raising an objection that for their decision to refuse legal representation must be taken on review. The criminal court says that this person is before me. I oversee the criminal proceedings, all of them, every complaint that comes. So if Mr. Bester comes to a criminal court and says that I'm chained, he must leave and draft some notice of motion and come to a criminal proceeding. Mr. Bester is going to be in the civil proceedings every day. If he's going to complain every day, he's going to leave that and come here with a notice of motion, serve it on the NPA and do everything that we've been subjected to, which I say that, truly speaking, if this is going to be our justice, it's going to be a miscarriage of justice. That why are you treating this litigant differently from all others? In every case that we've advanced that deals with principle, the objection is simply to distinguish the facts and avoid the principle itself. So if this is how now our law is going to be applied, obviously it's going to undermine our democracy that is based on the rule of law. Because the rule of law, or the issue of precedent, is an incident of the rule of law. If you are departing from the precedent, then you are violating the rule of law. Then, third point is the Zuma case. You were told that, and luckily I was privileged to argue the Zuma case, both of them, Part A and Part B. In Part B, I make oral presentation on the jurisdiction. It was literally allocated to me. And if you look at that judgment, majority of that judgment is dealing with jurisdiction. I dealt specifically with the issue of jurisdiction. I dealt extensively with the issue of Moyo. They were not eliminated on the distinction of facts. They said principle. What did the principle say? Part A of Zuma, of Mr. Ramaphosa, or the president versus Zuma, it was to interdict the private prosecution pending Part B, which was a review and setting aside of the private prosecution. The full court, obviously, the question of jurisdiction, it's for Part B. In Part A, they determine the requirements of interdict, but they pass a comment that they don't see a distinction between a civil court and a criminal court. But what did Part B say? What did Part B say? I'll take your ladyship to Part B, which is then the review and set aside of the private prosecution. I'll invite your ladyship to go to paragraph 68. I'm going to give citation. It was lied by my learned colleague in their heads, but I'm going to give the full citation. It's the President of the Republic of South Africa versus Zuma and others. 2024, Volume 1, SACR 32, GJ. This is what Part B said about that simplicity of saying that there's no distinction between a civil court and a criminal court. Paragraph 68. In the preceding paragraph, I'll just paraphrase what happened in paragraph 66 and 65 going to 67, and then read paragraph 68. So the court said the finding on jurisdiction is correct. So we're talking about the finding on jurisdiction, not the comment on the distinction. And my learned colleague relies on that distinction, but omits to say that the court was agreeing on the finding. They might be wrong. They gave reasons for jurisdiction, but they are right in that under certain circumstances which are established in Chint, which are established in Moyo, that it is the interest of justice that gives a civil court a jurisdiction to hear a criminal matter. It's not unfitted, but it's unfitted in criminal proceedings. In civil proceedings, you have to prove, or you have to adduce, or you have to convince the court that it's in the interest of justice to take a matter from a criminal court and bring it in a civil court. So this is what paragraph 68 says. After it discussed that it agrees with the jurisdictional finding, it says the distinction or lack thereof between civil and criminal court oversimplifies Mr. Zuma's comment. Who oversimplified is part A, that says that there's no distinction. Oversimplifies Mr. Zuma's complaint because notwithstanding that the two courts, the criminal and the civil, fall within the same hierarchy of the court, in the same division of the High Court, and are often presided over by the same judges as contended by the applicant. The High Court may only arrive at its decision in the manner provided in Section 14 of the Criminal of the Superior Court. Put differently, the High Court has only the power to make a particular decision in the manner and for the purpose provided in that provision. If not accordingly constituted for the purpose of making a particular decision as provided in Section 14, it lacks the jurisdiction. So now, what can we glean from this? We glean from the fact that that comment that was made in Part A oversimplifies Mr. Zuma's complaint. But it's right on the jurisdiction, on the finding. So now, this court, it drew a distinction between a civil court and a criminal court. But it's not saying that the other can hear a criminal complaint. Because when it goes further and determines...
But your argument is that, that's what I'm saying, your argument is that the civil court cannot hear this matter.
No, we can even go to our heads of argument, what we said about this particular aspect. We said the civil court does not have an unfitted jurisdiction. You must come and invoke it specifically. So why should we place hurdle to an applicant to leave the court that is constitutionally ordained, or the par excellence, in terms of the words of Moyo, the par excellence forum? You want to take it from the par excellence forum that does not have this straight-jacketed procedure and bring it to this procedure, then you'll be asking all this question about uniform rules. That engagement does not play out in the Criminal Procedure Act, because an application in the Criminal Procedure Act is not an application in terms of the rules. When a person says that I'm moving a bail application, they are not using Rule 6. In fact, they can even move it orally if it's not a formal bail. A formal bail does not even have to be accounted by a notice of motion. Is it not an application? It is an application. So the application in the criminal procedure, in the criminal proceedings, not necessarily the same, the application in the civil motion. But what you can do in this instance, if there are substantive issues, to not ambush your opponent, you forewarn them. You forewarn them that this is what we are going to ask. And because there are other state machinery that are involved, they need to come and tell the court, because the court can't say that the accused or Mr. Bester must have a laptop without having regard to the views of correctional service. Correctional service must come, and that's why they were brought.
That's exactly where we are.
Yeah.
The process through which you bring the correctional service before court, which process is that?
It's an application in the Criminal Procedure Act. It doesn't prescribe anything. Doesn't prescribe.
How do you then bring the correctional services in court, because they are not part of the proceedings in the criminal court?
You invite them through a notice of application. We've invited them, they came, they filed an answering affidavit. So that question is answered even by what happened. It happens in every case that I've referred.
How do you then notify them?
They were notified through a notice of application. A notice of application was served on them.
How was it served?
Yeah, it was served.
How?
It was served via email. And physical documents were also dropped at the correctional service.
Yes, it was served via email.
Yes, but it doesn't take this case any further. It tends to no point. whether it was served by WhatsApp, whether it was served by email, whether it's not in terms of the uniform court rules. And that's the point that I'm making. It's a simple point I'm making, and I've been making it the whole day. And I can't stress it further than that. This is what we've been doing throughout the day. Because you want to take him from the criminal court, you bring him here, then you say that serve it in terms of rules 4. It doesn't apply. It doesn't apply in the criminal proceedings.
And you are in the civil court now, where Rule 4 applies.
We did not come at our own volition. The matter was, the pleadings were already closed. What was left here was the heads of argument, not to reserve the application. The application had already closed. When this matter was set down, it was set down after the reply was filed. And then we then agreed.
And even at that point, when the matter was in the criminal court, the correctional services was not there.
They appointed legal practice. The notice of opposition says the respondent. Who is the respondent? The correctional service is the respondent. They don't have to come as the minister. They don't have to come as the commissioner. They come through the East THABO BESTER here. No. Is he represented? Yes. By who? By the legal practitioners. Is the correctional service here? Yes.
Mr.
I think that, my lady, that question is unfair.
No.
The notice of opposition, the respondent intend to oppose. Which respondent? Correctional service, the state. So I don't understand why a person can say that correctional service is not there when they file a notice of opposition and all respondents are represented in terms of...
And when was the notice of opposition filed, Mr.? When was it filed?
I'll ask my striking attorney to give me it has a court stamp here, 30 July.
30 July.
Yeah, it was served electronically and filed on 30 July. That is a stamp from the court.
On 30 July. And
Yes.
when were you at court?
We were at court on the 29th. That
Yes. That's exactly my point.
But
After the court had directed you to bring this matter before a civil court.
No, it had not directed. It took the decision on the 21st of October. At that time, there was a back and forth after the 29th, and that's what I've been trying to do. Your ladyship, without giving me an opportunity, would want to make a conclusion after having blocked me from making
on the 29th, what did the court say to you on the 29th?
The pleadings are not closed. Wait for the replying affidavit, then I will allocate. Either criminal or civil, they will decide. It had not decided. So it can't be said that on the 29th, that decision to allocate us to a criminal court, to a civil court was made. No. And that's exactly, throughout this is a prevalent problem that I'm facing here as a practitioner. I make a point, I'm interjected. Then at a later stage, that point resurfaces, and I'm blamed for not having... If your ladyship had exercised some patience and gave me an opportunity to explain, your ladyship would have seen how we got here. That's even our first ground in our structure, how we got here. I wanted to take your ladyship step by step of how we got here, and it was not going to take 5 minutes. Simply, we were there and we insisted that if we're in a wrong court, you make a jurisdictional determination. And the court, because it had already commented, could not. It was disentitled. It had already commented, passed the comment.
At what point did the court comment? On the 29th?
Yes.
Yes.
On the 29th it commented.
Yes.
That it's in its view. But it's not making a finding. It's a comment. And we said that we are ready to even argue the jurisdiction. And the court says, no, I'm going to wait for the pleadings. Once the pleadings are closed, then I'm going to allocate this. Then, after the pleadings, what happened? We made a follow-up.
Thank you, Mr. Miela.
Yes. Then, I won't take it further, but the record will show that when I try to make a point and take it to its logical conclusion, and then there's this interruption that my point is lost. Then, now, there is this issue of cost. I really don't understand why non-issues should determine the issue of jurisdiction. If the court is not competent to grant the cost, that means that the issue of cost can simply be dismissed or can simply not entertain it.
But your prayer for cost,
Yes. If we didn't make out a case for cost, it can be dismissed.
But which court has to determine that prayer for cost?
We asked that court that we went to.
Which cost? Which court? The criminal court?
Yes, we asked the criminal court.
In terms of which rule do you ask the criminal court?
We asked because of the court, its inherent powers to regulate its proceedings.
And to just grant you cost in the vacuum?
It cannot be simplified like that, truly speaking, and with utmost respect.
But in a criminal court, you will then have a prayer for cost.
It's not for our law.
Okay.
One, my learned colleague has already told you the circumstances under which it can happen, so that criminal court can grant cost. That's one thing. We know it can.
And
You had it from
the circumstances of this case have got nothing, are far remote
But
from.
I'm trying to answer. My lady, if your ladyship is telling me that sit down, I will sit down. Because
Mr. Miela, you just said, firstly.
Yes, firstly, I'm going to the secondly. So why am I being interrupted when I've not? The reason I say firstly because I have another point that I'm making. I wouldn't have to say firstly.
Make your second. You have made your first point. Move to your second point.
Secondly, there is I happened to find it last night. This case, but let me make this caveat. We are not hell bent on the issue of cost. All the prayers that are prayed for, it's not a must for a court to grant. Some of them actually they might not be granted. We might have asked for a gadget and they give him something else. We might have asked for this. Does that mean that they couldn't entertain it? They would entertain, the court could entertain it. So I'm going to give this citation that dispels this notion, and I'm calling it a misnomer, that a criminal court can grant cost. Firstly, in terms of that provision, it can. Secondly, the case of S versus Campus. Campus, it's CAMPOS 2002, Volume 1, SACR 233. That's a Supreme Court of Appeal judgment. So now, so this is what it says. Counsel for the appellant consequently applied for an order that the respondent pay the appellant's wasted cost occasioned by the postponement. This is an unusual order, though not that this court cannot entertain. The Supreme Court of Appeal is saying it's unusual. You can complain that it's unusual, but it can entertain. That's the word of the Supreme Court. It's an unusual order, but the court can entertain. What does that mean? It has jurisdiction to entertain it. Is it going to succeed? That's an issue of merits. Then it continues. This is an unusual order, though it can. I think that in the exercise.
And I think you are aware that it was at the stage of appeal when that request was made.
No, it was they were asking the cost for postponing the matter itself. Now it was in the appeal when they were saying that they are entitled to cost of that postponement in the criminal court. If your ladyship can give me an opportunity to read this, because that's what I'm trying to do. They were asking for the cost in the hearing itself, not the appeal. I mean, when you appeal a matter in subsequent forum, there can be an issue of cost. Then I think that in the exercise of its inherent jurisdiction, to ensure compliance with its own procedures and to protect litigants from loss occasioned by non-compliance with them, the court has a competence to make such an order. In doing so, however, it should tread carefully, as the proverbial opening of the floodgates should be avoided. Many cases postponed daily. Where are they getting postponed? In the criminal court. Many cases postponed daily, particularly in the lower court. In the lower court. Due to, for example, to the state not being ready to proceed with the trial. The reason, and this is just an example, the reason for that may be legal, and no blame may be attached to the state. Clearly, in such cases, no such cost order should be made. Practitioners are normally able to return to their offices to continue with their daily tasks. The position in this court is different. Matters are set down well in advance, and the parties of the
And which court is that? Which court is that?
This is then, it's talking about the Supreme
Court of Appeal.
Yes.
This is where an order for cost was requested, Mr. Mayor.
But what I've just read here, it says that in the lower court it can be granted, but we must avoid opening floodgates. That's what it says. It dealt with the two instances. I don't know why one aspect is getting avoided. That's what it says. I can't say anything. That's why I'm reading it verbatim, because now I'll be accused of deviating. Your ladyship then chooses the other aspect. Obviously, it's coming as an appeal. It's coming from somewhere. And the complaint is that on that day, that's why the court says that no, but you are able to even leave your office. Then it says that the difference here is that in the Supreme Court of Appeal, so these matters are done in advance. You can ask for postponement in advance. It says that, but if you allow that cost order to be granted easily in the lower court, you're going to open a floodgate. You're going to open a floodgate where the state will be multiplied with cost upon cost upon cost. So it drew that distinction. It drew that distinction. So the issue of cost is not foreign. It's not foreign in terms of what my learned colleague has said. It's not foreign in terms of this court. So I really don't understand what hurdle does Mr. Bester have to pass to make a point in court. It really can't be that the point that Mr. Bester has to make has to be super, I don't know, has to be super over every precedent, and it must fit to every fact that has been determined in our case law. That's not how judicial precedent operates. It's the issue of principle. And I'm saying this because this happened throughout these proceedings. You make a point, there's counter, and avoid the principle. You make a point, there's counter, and avoid the principle. Not even one point that I've made.
Mr. Muyela?
Yes.
At every turn when I asked a comment from you, it's because I was trying to show you how the point that you are making, it's not applicable to the matter before me at this moment.
But the principle is that the court can grant cause.
Thank you.
Yeah, that's all. And then let me look at the last point. So I can't, we argue cases through principles. Then, can I just ask for my attorney to address these points that were raised by my colleague? No further submission, my lady. My learned colleague said that, if I heard him correctly, he said that we must be mulcted with cost at a situation wherein we did not come here at our insistence. We were brought here through a court directive by the JP, so that a court that is hearing this matter should determine whether it is civil or criminal, and not to determine any other point. So I don't understand why it should be mulcted. In fact, we didn't even understand what is the purpose of this proceeding, because the criminal court could have determined that point and say there's no jurisdiction. But we accept what then happened. And then we say that we're going to have a day where we're going to argue this, whether it's a civil matter or not. Once the court says it's a criminal matter, then the JP would allocate it in a criminal court as the court visits.
Thank you, Mr. Mayor.
Lady, may I just correct my learned colleague, but you can just look at paragraph 8 of our heads. We referred the court to the fact that jurisdiction 7 and 8 is a binary concept, and that the court Miramoto is entitled to raise it. So the accusations that he made is not, I think, entirely justified. It was actually, this point was actually raised by the Judge President when this matter was on the pre-trial court trial. My learned colleague and the Judge President already had a long debate with regards to it. Please shoot.
Thank you, Mr. Snellenberg. Judgment is reserved. Parties will be informed of the date of delivery. For a chance.
All right.